The first time I realized something was wrong, it wasn't because of a mistake, or a missed payment, or even a legal threat, but because a contract I had already signed appeared back in my inbox with one sentence highlighted that I was certain hadn't been there before. And I remember staring at it longer than I should have, trying to decide whether I had failed to notice it earlier or whether I was about to discover how fragile memory becomes when too much depends on it. My name is Nathan Rhodes. I was 36 years old at the time. For 9 years, I had owned and run a small B2B automation firm in Chicago. Nothing glamorous, nothing consumer-facing, but the kind of infrastructure work that keeps trucks moving, invoices paid, and disputes from escalating. I built the company slowly, deliberately, starting as a freelance consultant, then hiring one developer, then another, reinvesting everything back into the business, turning down rapid growth offers because I preferred predictability over headlines. By year 5, we had a reputation that mattered more to me than revenue. Clean audits, conservative projections, contracts we never broke. Clients stayed for years because our systems didn't fail quietly, they failed transparently, which in logistics is often the difference between trust and litigation. That reputation was the only real asset I believed couldn't be taken from me, because it wasn't written into any ledger. The opportunity that changed everything arrived in the form of a call from a procurement director at a national freight carrier, the kind of company that didn't usually speak to firms our size unless they were being acquired or quietly evaluated for replacement. They had reviewed one of our case studies, they liked our approach, and they were exploring a pilot that could scale nationally. The numbers they mentioned were conservative in tone, but transformative in implication. A multi-year services agreement that would stabilize cash flow, allow us to hire deliberately, maybe even let me pay myself something resembling a market salary for the first time. It wasn't a sudden offer. That was part of what made it feel legitimate. There were weeks of calls, technical reviews, security questionnaires, meetings with people who clearly understood what they were asking for. At every step, I reminded myself that this was still just a contract, not a miracle. I involved my team early, brought in external counsel, pushed back on timelines when they felt aggressive, all the behaviors I had trained myself to perform precisely so I wouldn't be dazzled by scale. Still, I would be lying if I said the pressure wasn't there. Competition had tightened margins. 2 long-term clients had merged and reduced spend. My cash reserves, while healthy on paper, were thinner than I liked to admit. The carrier's representatives never mentioned our financial position directly, but they didn't need to. Their urgency was framed as opportunity, a window in a competitive procurement cycle, a chance to prove ourselves before larger vendors locked in. The draft contract arrived thick, precise, and professionally neutral, the kind of document that signals seriousness rather than threat. I remember reading it late one night in the office, after everyone had left, taking comfort in the familiar cadence of clauses and definitions. There were provisions that expanded our responsibilities, of course, higher service level guarantees, broader audit rights, indemnification language that leaned in their favor, but nothing that in isolation violated norms for an enterprise client. Every concern I raised was met with explanation rather than resistance. Their legal team was efficient, polite, and unhurried, which paradoxically made me trust them more than if they had tried to rush me overtly. When I signed, it wasn't out of desperation or ego, but out of what felt like a rational assessment that this was the next logical step for a business that had already survived long enough to know its limits. For the first few weeks after execution, everything aligned with expectation. Onboarding sessions ran smoothly, data flowed through sandbox environments exactly as modeled, my team performed well under scrutiny. I began to think less about the contract and more about execution, which in hindsight may have been the first real mistake, because contracts only matter when something goes wrong, and by the time I noticed the questions changing tone, the assumptions shifting slightly without explanation, and the metrics being discussed in meetings that no longer included me, I was already operating inside a framework I hadn't fully mapped. It wasn't dramatic, just small things. A request for broader historical data framed as quality assurance, a revision to reporting intervals justified by internal policy, an offhand comment from one of their analysts about how liability would be clearly assigned if variances appeared. None of it rose to the level of alarm, and that was precisely why I didn't act on it, because in my experience, real problems announce themselves loudly, and this felt more like administrative noise than structural risk. The night I reopened the contract and saw that highlighted sentence about sole operational accountability in the event of downstream financial loss, my first reaction wasn't fear, but confusion, followed by the quiet, unsettling realization that I could not say with certainty whether it had always been there or whether I had simply believed too strongly that experience alone could protect me from what I hadn't yet learned to look for. After noticing that sentence, I didn't panic, which in retrospect says more about my mindset than the document itself, because I had spent years training myself to assume competence on all sides and to distrust emotional reactions to legal language. So I did what I always did when something felt off. I traced the version history, reopened my notes from negotiation calls, and tried to reconstruct the logic that had led me to accept terms that now felt heavier than I remembered. The negotiation phase had been methodical rather than aggressive, structured around milestones and review cycles, with their procurement director acting as the central point of contact, a man named Allen who spoke in precise, non-committal sentences and never raised his voice or used urgency as a blunt instrument. Deadlines existed, but they were framed as external constraints tied to internal budgeting approvals rather than leverage, and every time I asked for more time to review a clause, it was granted without complaint, which made it harder to argue that I had been rushed. The legal language itself was dense but familiar: expanded indemnification tied to financial losses directly attributable to system failures, audit rights that extended to sub-processors and data handling practices, and a limitation of liability that capped damages only after certain thresholds were exceeded, thresholds that seemed theoretical given our historical performance. One clause in particular, the one now highlighted in my inbox, referred to sole operational accountability in cases where integrated systems fail to reconcile transactional discrepancies. At the time, it struck me as a clarification rather than a trap, because our entire value proposition rested on reconciliation accuracy, and I believed, sincerely, that clarity favored the party doing the work correctly. My external counsel, a mid-sized firm I had used for years, flagged the clause as broad but not uncommon, recommending minor wording adjustments that were negotiated down to what they described as a reasonable compromise, and I remember accepting that assessment because it aligned with my own bias towards seeing myself as competent enough to manage operational risk. There was also pressure, though it rarely appeared as such on paper, coming instead from overlapping signals: a competitor rumored to be bidding, a fiscal quarter closing, internal champions at the carrier who wanted the project approved before leadership changed. My operations lead worried about scaling too fast. My developer team was excited by the technical challenge, and I found myself mediating between caution and ambition, telling myself that growth had always required controlled risk, not avoidance. When I signed, it felt less like a leap and more like a continuation of a trajectory I had already chosen years earlier. The first weeks post-signature reinforced that narrative. Onboarding documents were exchanged, access credentials provisioned, and we were granted read-only visibility into certain datasets to validate assumptions, all within the scope described during negotiations. Then the requests began to drift slightly, not in magnitude but in framing, with emails asking for temporary elevated access to historical billing data to benchmark anomalies, or suggesting that we adjust key performance indicators to better align with their internal reporting standards, changes that were presented as procedural rather than substantive. None of these requests violated the contract explicitly, and in isolation, each seemed reasonable, even collaborative. But taken together, they shifted the center of gravity away from our original scope. Our counsel advised documenting everything, which we did, but they saw no immediate grounds for concern, noting that enterprise clients often recalibrate metrics during early phases. What unsettled me was less the requests themselves than the way they were communicated, increasingly through group emails that excluded me, or through analysts who referenced decisions made upstream, language that implied momentum beyond my direct influence. I noticed that performance reviews began emphasizing variance potential rather than stability, that questions focused on hypothetical failure scenarios instead of actual outputs, and that audit language, once dormant, surfaced casually in meetings as if to normalize its presence. Still, I continued to believe that transparency and cooperation would resolve any ambiguity, because that belief had served me well for nearly a decade. It was only during a routine status call, when a senior executive I had never met summarized our role as the accountable layer in a complex stack, and no one corrected him when he described our system as the primary point of failure for any downstream discrepancy, that I felt a shift I couldn't rationalize away, a quiet understanding that decisions about my company were now being made in rooms I wasn't invited into, and that whatever protections I thought the contract offered, they were already being interpreted by people whose incentives no longer aligned with mine. The collapse did not begin with a crash, but with a notification, a formally worded email from the carrier's compliance department informing us that a routine audit had identified reconciliation discrepancies exceeding agreed tolerance bands, and that pursuant to Section 8.4 of the agreement, they were initiating a full operational review. Language so measured that it took me a full day to understand its implications. The discrepancies themselves were not fabrications. They were real numbers drawn from edge cases we had already documented, timing gaps between systems outside our control, but the way they were aggregated and framed transformed statistical noise into apparent failure, and by the time I produced the documentation showing causality, the narrative had already hardened. Access requests escalated from temporary to mandatory. Audit scope expanded to include client-specific configurations that predated our involvement, and what had once been collaborative data sharing became unilateral extraction, justified by the contract's audit rights. Within a week, our operating account was flagged by our bank after receiving notice of a pending indemnification claim, not a judgment but a precaution, enough to slow payments and trigger internal compliance reviews that froze outgoing transfers until clarity was restored. I informed my team carefully, avoiding language that might induce panic, but the stress manifested anyway in small ways. Developers double-checking code that hadn't changed, my operations lead asking the same questions repeatedly, as if repetition might produce certainty. Legal notices followed, each referencing the same clause I had fixated on earlier, now interpreted expansively to assign us sole responsibility for downstream financial impact. And while our counsel contested the interpretation in writing, the process itself created momentum that did not require immediate resolution to cause damage. The carrier's communications grew increasingly procedural, routed through legal and risk teams rather than project stakeholders, and performance meetings were replaced by compliance calls, where metrics were presented without context, charts stripped of explanatory annotations, variances discussed as liabilities rather than data points. At the same time, Bird began to circulate in the industry, not as an accusation, but as a caution, because large companies rarely need to be explicit to influence perception, and soon 2 long-term clients asked whether we were experiencing instability, phrasing that allowed them to disengage without accusation. One postponed a renewal pending resolution, another reduced scope citing internal risk policy, decisions that were rational on their side and devastating on mine. I spent nights reconstructing timelines, replaying conversations, searching for the moment I could have acted differently, and days responding to emails that framed cooperation as obligation. Internally, I became more guarded, measuring every sentence, aware that anything I said could be documented, quoted, reframed, and that awareness isolated me more effectively than any explicit exclusion. When our bank formally notified us that accounts would remain restricted until potential liabilities were quantified, I understood that regardless of how the dispute resolved, the damage to cash flow alone would force layoffs, a reality that stripped the situation of any remaining abstraction. I informed my team, accepted resignations I couldn't prevent, and watched the business I had built contract under forces that were technically lawful and operationally indifferent. The final confirmation arrived not as a verdict but as silence, when a client I had worked with for 7 years stopped returning my calls, later explaining through an intermediary that their board had advised minimizing exposure. And in that moment, it became clear that even if the audit ended tomorrow, even if the claims were narrowed or withdrawn, the loss was already locked in, because trust, once reframed as risk, does not recover on a timeline that a small company can afford. The understanding did not arrive as a revelation, but as an accumulation, fragments that only aligned after I no longer had the energy to resist their implication. While responding to one of the later audit requests, I noticed that the data fields being requested no longer corresponded to any open discrepancy, focusing instead on configuration logic, exception handling thresholds, and the decision trees we had built to route anomalies, details that were irrelevant to fault assignment but essential to replication. In another thread, an analyst referenced an internal tool name I didn't recognize while describing behavior identical to our system's output, a coincidence that would have meant nothing months earlier, but now lingered. I began reading communications differently, not for what they accused us of, but for what they assumed they already knew, and in that shift, the pattern became clearer. The project's success or failure had stopped mattering once enough of our operational logic had been extracted under the cover of audit and compliance. A former colleague, now working at a consulting firm adjacent to the carrier, mentioned in passing that they were rolling out a new internal reconciliation layer, crediting efficiency gains to insights gained from recent vendor engagements, a phrase so generic it could not be challenged without sounding paranoid. I pulled archived versions of the contract and noticed how carefully the language around data use had been broadened during negotiations, framed as quality assurance, but written to survive scrutiny. And I felt a dull, belated recognition that the clauses I had accepted as neutral were in fact instruments. The psychological weight of that realization was heavier than the financial loss because it reframed my role not as a partner who had failed, but as a resource that had been consumed. And yet even that framing offered no relief, only a different kind of responsibility. I replayed every decision, every moment where I had chosen cooperation over resistance, wondering whether caution would have changed anything or merely delayed the outcome. And the doubt was corrosive precisely because it had no clear answer. Shame settled in quietly, not because I had been deceived, but because I had believed that professionalism alone could neutralize power asymmetry, a belief I now saw as both naive and necessary for the kind of work I had chosen. Anger surfaced occasionally, but it never found an external target, turning inward instead, manifesting as insomnia, irritability, and an obsessive review of documents that could no longer alter events. No one came to my defense, and I did not expect them to, because the carrier had done nothing that required moral justification in the public sense, only strategic explanation, and large systems are designed to absorb that kind of ambiguity without friction. The final decision arrived as a letter from their legal team offering a settlement that would limit further claims in exchange for confidentiality and a narrow admission of operational shortcomings, a document that did not accuse me of intent but required me to accept a version of events that I knew was incomplete. Refusing it would mean prolonged dispute, continued account restrictions, and the near certainty that whatever remained of my reputation would be defined by unresolved risk rather than quiet closure, while accepting it would formalize a narrative that assigned me blame for a collapse that had been engineered to extract value before it occurred. I read the letter repeatedly, aware that neither choice restored what I had lost, and that whatever I signed next would not be about winning or losing, but about deciding which version of the truth I was willing to live with when the noise finally stopped. I accepted the settlement, not because it was fair or because it acknowledged what had actually happened, but because by then fairness had become an abstract concept measured against realities I could no longer afford. The admission was carefully worded, narrow enough to avoid explicit falsehood, but broad enough to satisfy their risk committee, and when I signed it, the process moved with the same efficiency that had characterized every interaction from the beginning. Accounts were unfrozen in stages, liabilities capped, and communications ceased, not with closure, but with administrative finality. By the time the funds became available, there was little left to preserve. The team had dispersed, the lease on the office was terminated, and the company existed only as a legal entity winding itself down with deliberate restraint. A few clients returned calls out of courtesy, but none resumed work, and I did not push because trust does not respond to argument once it has been reclassified as exposure. What remained was the residue of habit, the instinct to document, to review, to anticipate risk, now detached from any structure that required it, and the quiet realization that the algorithms I had built, the ones I had once believed were inseparable from my judgment, were already functioning elsewhere without my involvement. I did not pursue further action, not out of resignation, but because the cost of continuing would have been measured in years and identity rather than money, and I had already lost enough of both. The months that followed were unremarkable, which in its own way was a form of recovery, filled with temporary work, cautious conversations, and the slow reconstruction of routine without the illusion of permanence. I learned to separate competence from control, to recognize that diligence does not neutralize asymmetry, and that professionalism, while necessary, is not protective in environments where incentives are misaligned. The anger faded not because it was resolved, but because it could not sustain itself without a future to act upon, leaving behind a more durable clarity about what had been taken and what had been offered in return. I no longer believed that contracts existed to define mutual understanding. I understood them instead as instruments that allocate responsibility in advance of trust, and that difference, once seen, cannot be unseen.